you so much, all of you, for coming. And I'd like to say good afternoon to Dana and Diana and good morning to Lisa. Now, Lisa Alexander is a specialist family lawyer in British Columbia, Canada. And I know Lisa from our membership of the IACP, which is the International Academy of Collaborative Practitioners, and she's a committed collaborative lawyer. Dana Rone is a specialist family lawyer, a mediator and a trainer from Latvia. And Diana Carrillo is a family lawyer with a strong international reputation based in Madrid. She's a fellow of the International Academy of Family Lawyers, and I know her from there, and also because we've had each other on the same side quite recently, maybe about a year ago. Forging connections with international colleagues has never been so important as now for UK lawyers. We are the pariahs of Europe. We've left the EU and our application to join the Lugano Convention has been rejected. So we'll be never sure when we're drafting nuptial agreements if the jurisdiction clause will be upheld in any other jurisdiction. So it's incredibly important to reach out to people that we trust in other countries and to make sure that we have a network of people that we can rely on for sound advice. And that is the background to today's webinar. The purpose of the webinar is to share our experience of how nuptial agreements work in our respective countries. Now, in England, nuptial agreements are not binding in our family courts, but they are of compelling importance if both parties have had legal advice, they've both made financial disclosure, the outcome on separation is fair and meets the needs of the parties and any children, and the agreement is made without fear or duress. There's no need to choose a nuptial agreement on marriage, and there's no default position in terms of excluded property or future assets, and there are no formalities in terms of registration. I know that in your jurisdictions it will be very different, so I have several questions to ask Diana, Lisa and Dana, all of which will demonstrate the importance of taking cross-border legal advice from people like these if your clients are likely to reside in other jurisdictions or they have assets abroad. So I'm going to start with Dana, because she's first on my screen, and with the first question. And Dana, that's, do clients in Latvia have to comply with any formalities if they enter into a nuptial agreement?
Yes, thank you for the question, and here is the answer. In Latvia, nuptial agreements have to be registered in a public register called Register of Enterprises. Register of Enterprises is a public body which holds a number of registers, and one of these registers is a Register of Nuptial Agreements. So the nuptial agreement is only in force if it is duly registered in the register. So which means for the parties, for the spouses or persons, yes, I'd say for the spouses who want to register their property relations, they have first of all to sign a nuptial agreement, and not only to sign, but to sign in the presence of notary public, because this nuptial agreement must be in a form of notary act. Second thing, this nuptial agreement has to be registered, and to make it registered, a specific application form has to be filled in and to be submitted to the Register of Enterprises. The third thing, a state fee has to be paid. And only if three components are fulfilled, then this agreement can be registered. In those cases, when we in Latvia deal with situations where there are nuptial agreements concluded abroad and not registered in a national register, like legal disputes arise of whether or no this nuptial agreement is acceptable for the Latvian national law. And in the most of the cases, we understand intention of the parties, but it is still not binding and not mandatory in Latvia. So my advice to the persons who wish that their nuptial agreement is enforced here, make it registered in Latvian National Register.
Thank you, Dana. And Diana?
Good afternoon from Spain. Thank you, Kim, for inviting me to this webinar. Yes, in Spain, we have to comply with formalities. For any pre or postnuptial agreement to become a legally binding contract in Spain, both spouses must simultaneously sign before a public notary. It is absolutely necessary. Also, another reason for this formality is that the agreement is not legally binding against third parties who act in good faith until it has been registered in the Spanish civil registry. So either the notary takes this agreement to the civil registry, or the parties themselves. They may take the public deed to the civil registry, otherwise it will not be legally binding. Everything has to be done in front of the notary. Also, they may sign either prenuptial agreement or postnuptial agreement. Yes, they may even sign it the day of the marriage, before the marriage, or during the marriage. But in any case, it has to be signed in front of the notary. And in case that they sign before the marriage, then the marriage must be performed within the year for it to be valid. So yes, in Spain, everything is before, well, all these agreements, they need to be signed in front of the notary.
Right, thank you. And Lisa, talking about formalities, the sort of formalities that you would have in British Columbia?
So we have no mandatory formalities in British Columbia with regard to nuptial agreements, and we use slightly different terms here. So for couples that are not intending to be married, to become legal spouses, but are living together in a marriage-like relationship, we would use the term cohabitation agreement. If it's an agreement in anticipation of marriage, we would call it a prenuptial, similar to Spain. And then an agreement entered into during marriage would be a marriage agreement. And there are no governmental requirements for formalities. However, in terms of enforceability, in order to be considered an agreement subject to our Family Law Act, it has to be in writing, identify the spouses clearly, identify their understandings and responsibilities and rights to each other, and their signature. All the agreements must be signed, preferably in front of a witness who physically watches them sign, but that witness can be anybody. It doesn't need to be a notary or a lawyer.
Now that actually sounds quite like the UK experience, I think. Maybe not entirely surprising. And the Latvian and the Spanish experience in terms of formality sounds more similar, I think. Mm-hmm. So my second question, and it's to you, Dana, is when you're drafting a nuptial agreement, postnuptial or prenuptial, what is your preference? Do you have two lawyers? Do you do it through mediation? Do you do it through collaborative law? How do you like to do it? And how does everyone else like to do it?
Mostly in Latvia, one lawyer is preparing a draft of nuptial agreement. And then after this nuptial agreement is approximated with the client, if the draft is sent to the opposing party, where the draft is analyzed together with a lawyer of opposing party. In Latvia, nuptial agreements are quite simple. We either have a nuptial agreement on complete separate regime of the assets or complete mutual regime of the assets. So if the parties have come to the agreement that they will have either one of these agreements, well, mostly there are no discussions anymore left to be discussed. So there is little cooperative work between lawyers because there are no disputes at all. At times, even the nuptial agreements are prepared by notaries public, which are neutral public bodies with a competence to help drafting legal documents. Regarding the mediators, there is no statistics how many times mediators are helping to draft this nuptial agreement. My practice says that never. Mostly the mediators can discuss necessity to have nuptial agreement, but mediators mostly leave this job for the competent lawyers.
Yeah, so mediators are more about separating couples than couples who are about to embark on marriage.
Comforting them in the dispute, but not helping to draft this quite specific legal document, yes.
Yeah, I mean, in England, it's becoming more popular for mediators to be involved in nuptial agreements. What about you, Diana?
Well, this is one of my aims. I would really like that the people in Spain, the spouses or the future spouses, would seek advice from lawyers. But the truth is that they usually they don't seek advice from lawyers, and they go directly to the notary. The problem is that the notary is going to sign or is going to explain very, very briefly the agreement, but is not going to explain the consequences of the signature of that agreement. And because in Spain, we do not have much, it's not very common to sign agreements for the breakdown of the marriage. Usually we do it to alter the matrimonial regime. So the spouses attend the notary without the lawyers. And of course, when the breakdown, when there's a breakdown of the marriage, then they find out the consequences. And I have seen many, many nasty surprises. So, however, the pre or post nuptial agreement can be drafted by the lawyer, can be drafted by one lawyer, but I always advise that there should be two lawyers, because there's always this one lawyer who is going to advise to one party, or it's the lawyer of the husband, or it is the lawyer of the wife. So I would advise that two lawyers are used, but that is not the common practice. Mediators, there is now the mediators, as in Latvia, they are for separation, they are for divorce, but never for nuptial agreements. Lawyers are not included, and mediators even less. And collaborative law, no, there's no collaborative law. So really, they will go to the notary, and they sign before the notary without advice.
So I'm sensing actually, Diana, that you probably have lots of ideas and you'd like to change to be forthcoming. Now, Lisa obviously is a big collaborative lawyer, so I imagine she'll say something a little bit different too.
I am, and I have a lot of opinions about this particular topic. So a little bit of background. So in British Columbia, Canada has different provinces and territories, and the family law, the division of property, and the method of dealing with spousal support varies from province to province and territory. So I am only speaking about British Columbia law here, and it would be absolutely mandatory to have a lawyer involved from whatever jurisdiction. If there's even if there's assets in different jurisdictions in Canada, and then absolutely if there was assets internationally, I would be getting in touch with one of you. I think that from a relationship point of view, and that even though I'm a divorce lawyer and a family law mediator, it's one of the most unique opportunities to strengthen a relationship when couples can negotiate their prenuptial agreement together. I think that it's a very unsophisticated method of kind of drafting on one person's instructions in terms of keeping everything on my side and then presenting it to your future spouse. I mean, it's explosive. It is can be quite ruinous for the relationship, and I don't think that that's anybody's intent, but that's the impact of doing drafting without input from both sides. My strong preference is to use collaborative practice or mediation, where the future spouses are able to have frank and full conversations about not only what's important to them and why, but what is their understanding of various different clauses? Do they understand the impact of that clause right now in the early parts of their relationship? Is that their intention at 5 years? Does that match their intention at 15 years? And I think it's just a real money saver to have both lawyers present with both clients at the same time, because you can easily deal with any misunderstandings or misapprehensions. In our jurisdiction, I do a lot of these collaborative type of negotiations. We then decide who of the lawyers will draft the agreement, and then we'll often reconvene for another four-way meeting to go over the agreement together to make sure that it still matches everybody's understanding. And I've been practicing for over 20 years now and have yet to have one of these agreements surface upon separation as something that's problematic.
Well, I think that's probably the best answer in terms of what we all aspire to, because it is a kind of pre-marriage counselling, isn't it? Testing out each other's attitude to wealth, to children, to going back to work, to sickness and health and longevity of marriage. It's difficult conversations that probably need to be had and generally aren't had unless you have a prenup. This next question is actually probably quite a short one, which is, Dana, can nuptial agreements include provisions for spousal maintenance or child maintenance in Latvia?
The question is short, the answer will be larger. Yes, of course, in the nuptial agreement, it is possible to include clauses and other aspects. Strictly speaking, the law says that nuptial agreement is only about the property relations. So the law does not say that nuptial agreements could include any other clauses, but the practice shows that, yes, at times the parties write also other things. It is not practical and it is not widely used. Why? Because all aspects related to children can change any time. And even if we provide that after divorce, the children will live at one place, or the maintenance payments will be in the amount of one sum, that can always be changed, because if the situation of the spouses or children are changing. So most of all, only classical, strict property-related agreements are chosen by the clients.
For me, that's my understanding of how it is in Italy and many other jurisdictions. Is that the same for you, Diana?
Yes, it's very similar. Actually, yes, we may include any provisions regarding spousal maintenance or child maintenance, but there is a big difference. Because if it's regards, or as long as they are not unlawful, they're not contrary to the custom or the principle of equality between the spouses. And yes, we may include agreements regarding child provision, child maintenance, or parental responsibility. They are valid, but they're not binding. I mean, you can agree what you want, but it does not oust the jurisdiction of the court. I mean, the judge has full powers, so they are not enforceable, because the interest of the child is what's going to be taken into account at the time of the break of the marriage. As regards to spousal maintenance, is different. I mean, I have seen, not very common, but sometimes I've seen it. I've seen the renounce to spousal maintenance, and the courts usually consider, I mean, they do consider these provisions valid, but they, as long as they do not renounce to the right of to receive maintenance, is not detrimental to one of the spouses. But what I have seen is that the courts, yes, they consider them valid, but maybe not binding, because the circumstances may have changed from the moment that they signed the agreement. So if the circumstances change, then they will not enforce that agreement. Because, I mean, the moment the circumstances are altered, then they don't take that into account.
Yeah, so they'll enforce the capital aspects of the agreement, but they'll interfere with the maintenance if it proves to be unfair.
Yes. No, not unfair. No, it's not so much if it's unfair. If it's the circumstances have altered, usually it has to do with being unfair. Let's say that usually it's the wife who's working and at the time of the marriage, but then she stops work and then she looks after the family, she looks after the children. So at the time of the breakup of the marriage, she hasn't got to work, she does not have property, she has nothing. Then in that case, the courts will understand that the circumstances have been altered and therefore the maintenance agreement is not respected by the court.
Yeah, I think that probably would be the same in England. Would it be the same in British Columbia, Lisa?
Yeah, it sounds very similar to what a judge might do in British Columbia, what Diana was describing. On the issue of children, our agreements can't contain items. You cannot pre-decide what would happen with an agreement. And as I was listening to Diana and Dana's answers, I actually was thinking about whether or not a judge would quite unfavorably view if people had purported to put in those clauses. I had a bit of a curiosity as to whether that would raise suspicions about the rest of the agreement. Not in any technical way, but in a what else have you put in here sort of way. Pardon me?
Maybe manipulative or overpowering or something.
Well,
like
just a sense of, hey, if you've made all of your decisions, what didn't you take into account? I want to nuance this answer just a tiny little bit, because there's usually two situations where a prenuptial agreement is being put in place. One is for a second or more relationship where the parties already have their work life fairly settled and their assets fairly settled. It's more likely that if you waive spousal support under those sorts of circumstances, that you would be successful in maintaining that waiver later on, particularly if full disclosure had been made. Although with the caveat that Diana said, that if it functionally turns out to be unfair, a judge could choose to set that aside. But the other one that we see a lot of young couples where they're potentially inheriting family money, or that the parents or part of the extended family runs quite significant corporate assets that may have trusts that are flowing in and through. And so their corporate and estate planning may involve having these children as part of the trust, where dividends or payments need to come out, but the expectation is for them to come back into the family. And we do a lot of prenuptial agreements in those sorts of situations. So we have to walk quite carefully in terms of what income is included for the purposes of calculating spousal support. And what income is explicitly excluded.
And Dana, do you have to have a nuptial agreement if people marry in your country? In other words, is it automatic, or is there a default position? In my country, you don't have to do anything, but do you have to sort of do a tick box when you get married? And I know that's true in some European countries.
Nuptial agreements are absolutely voluntary agreements, which can be concluded if the parties explicitly choose that. Most of the spouses get married without nuptial agreements. And if they do choose nuptial agreements, then approximately 90% of nuptial agreements are about complete separation of assets. If there is no nuptial agreement, then the general legal regime of the marital property is applied to the parties.
Okay. And Diana, is that the same for you?
So It's similar, but in Spain, there's always a matrimonial regime by default. I mean, we do not have to really choose. Absolutely, it's not necessary to choose a nuptial agreement, because the nuptial agreement is usually refers to the matrimonial regime. So it depends where you have the habitual residence after the marriage. Yes, so if you marry in Madrid, we will have a community of joint assets regime by default. As contrary to Latvia, in Spain, the community joint assets was the most common regime. Even though it is changing, it is true that young people are beginning to alter the regime. They go to the notary and they change this economic regime, which in my opinion, they are doing it without thinking of the impact, thinking of the consequences of the separation of assets. In Catalonia, for example, if your habitual residence is in Catalonia, in Barcelona, then you will be subjected to the separation of assets regime. But they have a different civil code, special for them. Yes, and it is not exactly a separation of assets as it would be in Madrid. In the civil code of Catalonia, they are much more protected in case of separation of assets. Why choosing separation of assets in what we call the common territories leaves you with absolutely nothing at the end of the marriage. I mean, if you look after the children and you are not earning anything, you are the homemaker, and the breadwinner is the one who has all the assets in his name, usually it's his name, you might find that at the end, at the time of the divorce, there's absolutely nothing. No job, no income, no assets. There's a little compensation in certain cases, but it is not that common. So, well, but that's the trend these days, to change to separation of assets. But we always have a matrimonial regime. We cannot, it's not like in the UK, like there is, you don't have, it is something that we don't understand. There is no matrimonial regime. Yes, we always have one.
So the same as Italy?
Yes, yes.
And I imagine that, Lisa, you might be a free-for-all like England.
Yes and no. What Diana's saying is quite resonant. So in British Columbia and all the other provinces in Canada that I'm aware of, it's a complete voluntary act to sign any agreement. And you are caught within the Family Law Act de facto. Our Family Law Act in British Columbia changed 8 years ago. And I still think that many people do not understand the full impact of it. Once you are living in a marriage-like relationship for 2 years, all of the property division and spousal support clauses apply to you, and they mandate that any increase in value of pre-existing assets is split. Any assets that are gained during the relationship are split 50-50. And this can be very shocking for people, particularly younger couples, where one has moved into the other's condominium. And we're in a jurisdiction here in British Columbia where almost everybody is a property millionaire because of just the wild real estate market. And so it's not uncommon to see gains of $500,000 or more in real estate, and that all of a sudden they're quite shocked to find out that even though their partner's name's not on title, they're actually splitting those gains, in many cases 50-50 if they happen during the relationship. So one of the other parts that has people quite shocked is that when this legislation came in, we all thought that there was very explicit excluded asset provisions, including any down payment that you might take from the equity in your house. And what's ended up happening 8 years on, a little bit less than that, is that if that came from my residence and you and I bought a joint residence together with our names on it, I have now been deemed to gift you my 50%. And all of a sudden you've gone from a 0 interest to a full 50-50 interest because we've registered this title to our house. So one of the ways that people are starting to pay attention is to do what are called excluded property agreements, just to say, when I came into the relationship, I had this, you had this. Regardless of how we use that money in our relationship, I will always receive out this and you will receive out that.
I wasn't expecting that. And it's different in other provinces.
Yes, it is. And that's the tricky thing in terms of working internationally, is that I think sometimes people get confused and say, oh, well, they live in Canada, therefore I'll phone my friend Lisa in British Columbia. And I explain, well, actually Toronto is Toronto is closer to Glasgow and I'm closer to Russia. And so I can't advise on any law outside of the province. And there are different property regimes in each of the law, and there's in each of the provinces, but there's also different assumptions. So if I take advice from lawyers across whatever province there might be assets in, as a matter of routine, to make sure that I have not accidentally given somebody an entitlement or taken it away.
Right, that's really helpful. My other question, and starting with you again, Dana, is how do you vary prenuptial agreements? Can you vary them, and how do you go about that?
Yes, the nuptial agreements can be amended and they can be terminated if the parties agree on that. And in the same way as nuptial agreements are signed, they can be amended, which means the parties again go to the notary public, make as a notary act these amendments, sign application to the Register of Enterprises, pay the state fee, get it registered. The amendments are very rare. There are, but they are really exceptional cases. So mostly either there is a nuptial agreement or it's not, but well, amendments is something which in theory exists, but which is not popular among the clients.
Is that the same for you, Diana?
It's quite similar. Yes, it's not very common to amend the nuptial agreement, but what is quite common these days is to replace the matrimonial regime that they had. The couple had the marriage. They had it from the marriage at the beginning of the marriage. As I said, it was by default the community of joint assets, which is some kind of it's 50-50, with the particularity that in Spain, all the assets before the marriage are ring-fenced. I mean, the community of joint assets starts only, all the assets acquired from the date of the marriage until the marriage finishes. So anything that you own, any of the parties, any of the spouses own before, that belongs to them and it is not taken into account. So that's ring-fenced, yes. But these days, yes, you can't replace the matrimonial regime at any time. You have to execute again a public deed, a nuptial agreement, and you always have to do it before a notary, always. The spouses, what they can do is they may liquidate the community of joint assets and they can start a new regime. Or sometimes, which is even worse, they replace the matrimonial regime and they do not liquidate the one before. So at the time of the breakup of the marriage, we find two different matrimonial regimes that we have to deal with. And the notary doesn't tell them. I mean, they're not informed. Lawyers, they need lawyers.
Is it easy in British Columbia to vary?
It's absolutely easy. From a technical point of view, it's exactly the same. Rewrite it, both people sign it, their agreements are witnessed. And what I explain to people is that it's easy to do and almost impossible to do in practicality, because the only time people want things changed is because they're not working for one person or they're fighting. And so the likelihood of somebody agreeing to vary an agreement voluntarily is so low as to be functionally impossible. So I always give my clients the one kick at the can speech, that they need to know that when they sign this, this is their one kick at the can. It needs to be right the first time, because the likelihood of somebody agreeing to change it is so low. I get around that by building changes, time-based or chronological-based changes in entitlement right into the agreement. I think that that's a stronger way to deal with these things, so that couples don't actually have to think about advocating for themselves to the exclusion of the relationship after a certain period of time, that they can genuinely stick this agreement in the drawer and be able to rely that it has been drafted in a manner that represents their agreement accurately at this point in time and this point in time, so that they don't have to fight for their rights at a time where things are probably going wrong if you're fighting at that point.
Yeah, I mean, the cases where I've had them, very rare, as you say, tend to be where one party, maybe the party with money, has committed adultery and is wanting to kind of maybe rejig the agreement and make it a little bit more generous to keep the marriage on track, but, you know, not a healthy scenario, as you say. And then the other question is, in my country, they're not binding anyway, but they are incredibly important if you follow the formalities. Are they always binding, Dana, in Latvia?
Yes, they are always binding, and let me explain. So the agreements in Latvia can be signed in three forms. Either that's a private document signed by both parties, either there is notary approval on the signatures, or the third option is a notary act. And the nuptial agreements are always signed in the form of a notary act, which means that the notary has fully explained to the parties the contents and the consequences of the agreement, and to later to apply to the court and to ask to recognize null and void some part of the nuptial agreement is always close to zero. It is impossible, because that's a notary act. Of course, theoretically, there can be a case that notary made a crime and against the will of the parties issued such notary act, but that's a theory. In practice, it is absolutely impossible. As soon as we see that that's a nuptial agreement, we immediately explain to the clients that there is no chance in the court to recognize it null and void. But there's another thing. These nuptial agreements can be recognized null and void by the third persons. For instance, if the spouses have intentionally signed the nuptial agreement to avoid some credit obligations towards the third persons, then these third parties who are offended can possibly raise a claim against either one of the spouses, and in that way show that this nuptial agreement was concluded in bad faith to avoid financial obligations. Mostly we see that in insolvency cases, where insolvency administrators are raising claim at court against that unfaithful party. And there is such a non-written rule that nuptial agreements who are younger, newer than 3 years, are under the risk of these court proceedings. It is very rarely, but this risk can happen. So mostly if the spouses feel that financial negative consequences are coming to either one of them, they prefer not to conclude a nuptial agreement, but to make artificial divorce. They just divorce and they agree on separation of the property in a divorce process. That's more safe. Thank you.
How's that resonate with you, Dan?
Well, we've got some similarities to Latvia. Like it is binding because it is once the nuptial agreement, in this case, usually the matrimonial regime, if it's signed before the notary, then it is absolutely binding. Well, it's actually binding even if you don't sign it before the notary, when you have the matrimonial regime by default. But in case you replace or not the matrimonial regime, it is absolutely binding because it is signed in front of the notary. You can't change that. But there's a big difference with Latvia. Our notaries do not explain the consequences. They may explain the content, but in a very basic way. Separation of assets, your assets are his and your other assets are hers. Okay, thank you. But no, it is much more to it, and they will not explain it. So yes, it's absolutely binding. Once you have signed this matrimonial regime in front of the notary, it is binding. But, well, they can be declared invalid. Not very often, but they can be declared invalid because the marriage articles are governed by the general rules governing contracts. This is a contract. So if there is a lack of consent, because there has been duress or error or intimidation, and you can prove it, I haven't seen many decisions, there are some decisions, but not many. Or as Dana said, the courts, for example, to commit a fraud against third parties in order not to pay a debt. Well, in that case, there wouldn't be a cause of the contract because the cause is a fraud. But you have to prove it, like everything else. And as you know, in Spain, everything that is not proved with a document is no evidence. We are document lovers.
And you, Lisa, is it always binding, or when is it?
No, I think we're more like England in this impact. But I do want to make a distinction between binding and enforceable. So it's not like Latvia or Spain that this document has powers because it was signed in front of a notary. And it's quite rare for documents to be signed in front of notary here unless they're sworn statements. But judges give significant deference to the contracts that parties have believed themselves to enter into. And what would normally happen here is that if a pre-marriage agreement or a marriage agreement was attacked in court, a judge will, there's a variety of different legal tests, and I'm not going to go through the specifics of the legal tests, but I can say as a general principle, if there has been full and robust disclosure so that all of the assets and the debts are listed with accurate values. We just had an interesting case come out of our Court of Appeal quite recently where a fairly well-known politician did not fully and accurately disclose the value of the assets that he was trying to protect. And the agreement did get varied to pay his now former spouse more money. So full disclosure, accurate values, legal advice to both parties, and no duress. It's very likely that a court will uphold that. And there have been times where they haven't. I think that overall, court is looking to make sure that the application of the agreement at the time of separation is fair, not just fair when they signed it, but at the time of separation.
Yeah, that's pretty much identical to how it is for us. And there's a final question, which is how do you deal with nuptial agreements from other countries? So if the couple relocate to Latvia and they have a nuptial agreement in England, what would be the attitude of your court in Latvia if they divorce? Would you ignore it or would you try to uphold it?
I will say the most popular answer of the lawyers, it depends. It really depends, and the Supreme Court of Latvia has not ruled yet so far on the recognition of nuptial agreements concluded abroad. But let me explain. There are two criteria which are specific to Latvia, and this is public credibility of nuptial agreements and clarity of contents, understandability of the contents. And I would say that if the nuptial agreement, which is concluded abroad, if it meets these two criteria, so public credibility, which means registered somewhere publicly, And if the contents was explained to the parties, then most probably we could come to the conclusion that such nuptial agreement would be enforced also in Latvia. But if there is a lack of either one or both of those criteria, then most probably this nuptial agreement will not be accepted. But there is no clear answer from the case law, neither a thing could be interpreted from the law.
Yeah, and how's it going in Spain, Dana?
Well, in Spain, we would respect a nuptial agreement from other countries as long as the nuptial agreement is drafted according to the formalities of the country where it was signed, and as long as it does not include any unlawful provision, or it doesn't go against the general principle of equality between the spouses. In Spain, sometimes we find a nuptial agreement from Islamic countries, Morocco mainly, and in that case, yes, if it goes against the international public order, and it will be examined by the courts, and in that case, it will not be respected. But as long as it's not, it does not go against the general principle of equality, and all the formalities of the country where it has been signed, as they have been complied, then we would respect it. I have to add that a Spanish notary in Spain is an authority, can be an authority. We are one of the few countries in international law, in the UE, yes, in Europe, that the Spanish notaries are authorities. They can divorce, they can marry, yes, they can even in the inheritances, you can go to court if you don't agree, if there is a disagreement between the beneficiaries, between inheritors. But if there is an agreement, the only way is to go to a notary. So really the notary is an authority, and it is recognized in Europe as an authority. So it's a little bit different from other notaries, yes? But yes, as long as it does not go against the international public order, we will respect them. Another thing is what Dana said. Well, it depends if, sometimes there is if depends, but as a general rule, yes, it will be respected.
The reality, I suppose, is it depends which country you're talking about, doesn't it? If it's a country that resonates with your own jurisdiction's idea of fairness, that's fine. If it's way off the mark, then you might find you'd interfere, perhaps.
No, fairness, no. It's international public order.
Right, no, okay, and that will be true in Latvia as well. More about international public order than fairness.
Well, theoretically, it should go hand in hand, but the public order would be decisive rule probably. Yes, if it would be absolutely contrary to the public order of Latvia, then we would not accept such a nuptial agreement.
And how about you, Lisa?
Quite different, I think. If it's mandatory to sign an agreement prior to getting married, and they have relatively standard terms, so non-variable, I'm thinking that I'm almost certain that that wouldn't be enforced in Canada. So for instance, what Dana describes in Latvia, how it's all very standard and you just get into it. I would advise a client that would not be applicable here, particularly if all of the assets had been gained and resided in British Columbia. Now, it's a different matter in terms of if you have some assets in one jurisdiction and some in the other. And I would be phoning Dana and saying, look, what do we do with the Latvian assets? How would those happen? Here's what I think would happen with the British Columbia assets. If it's an agreement that has been negotiated, full disclosure, values, legal advice signed in front of lawyers, I think the courts are going to give quite a lot of deference to that, provided that it is within the British Columbia version of fair. And, fair being every lawyer's four-letter word, because it's so difficult to define. I would be advising clients if they have significant prenuptial or marriage agreements due to interfamily wealth or jurisdictional assets, that they must have any agreement drafted in British Columbia reviewed in their new jurisdiction and either amended, if it is easy enough to just do a one-page agreement saying, you know, we acknowledge the terms of this agreement in British Columbia and wish it to apply in Spain, then there's that. Or more likely, you know, we acknowledge the terms of this agreement negotiated in Spain and wish for these provisions to apply to us fully in Canada. Certificates of independent legal advice. I think that, you know, that is much more, I think a court is going to defer to parties' desires at that point, because it's then very clear that they've thought of these issues, have reviewed them and want to be bound by it.
Well, I think that's probably the conclusion that we reach at the end of this discussion, and thank you so much for coming, is that mirror agreements in different jurisdictions are absolutely essential, aren't they? We can't make any assumptions at all. No matter how close we might feel to another jurisdiction, it could be radically different. And it's good to know that if I have any problems in Latvia, in Spain and British Columbia, I know exactly where to come. And it's really great to see you all, and thank you so much for your time.